second instance of contact is on 3rd of September. And my lord, you issued orders at 10 a.m. There was no appearance. You issued further orders at 3 p.m. There was no appearance. My lord, those are 3 instances. My lord, on 5th of September, equally, you issued orders that he appears on 5th of September at 10 a.m. He did not appear. A 5th instance of contempt in court. You were gracious enough to direct that he appears at 3 p.m. My lord, he did not appear. Cumulatively, these are 6. Today morning, it's the 6th instance that the Inspector General of Police, the first respondent, has refused to comply with this court orders. My lord, that is the context within which we find ourselves as petitioners in this matter. Will this court give another chance for the Inspector General to appear before it? My lord, if that is given, then it will be a further violation of the Constitution, particularly Article 10 of the Constitution. The Inspector General has a duty, which duty is abrogated. Your directions were that he himself, not his deputy, appear before you. Having given that context, my lord, I want to invite President Nelson Harvey to submission.
My lord, it was not my expectation that I will stand here today, having stood in this very court about 5 years ago before your brother Justice Ruto on a matter similar to this. Having appeared before this court again 7 years before your very same brother Justice Ruto on a similar matter. I'm talking about the matter of Miguna and the matter of Willie Kimani. My lord, the conduct of the first respondent must be deprecated by the court. And in the strongest terms possible. My lord, the very criminal justice system that the first respondent stands for is incapable of performance, but for reliance upon court orders. It will therefore be turning logic over its head to allow the National Police Service, which comes to this court day after day for summons, to compel attendance, to warrants to enable search, to fail and attend court, to give an explanation as to the whereabouts of 3 Kenyans. Lord, it is for that reason that at the tail end of this discourse, we will ask the court to do 2 fundamental things. 1, to convict the holder of the office of Inspector General of National Police for contempt of court. And 2, to sentence the holder of that office to the highest permissible penal consequence. And if 6 months is the highest permissible penal consequence, it must be cumulative for the 5 orders hitherto disobeyed. And fundamentally, my lord, this is not a personal office. It is a public office. So that as you convict and sentence, my lord ought to make a declaration of violation of the Constitution. My lord, allow me just to refer to 3 authorities and in very brief. My lord, the first case is the case of Dr. Fred Matiang'i. Dr. Fred Matiang'i versus Miguna Miguna. Sorry, it's Miguna Miguna versus Dr. Fred Matiang'i. Petition number 51 of 2018. It's reported as 2018 UK law. Lord, your brother, Justice Odinga, as he then was a judge of the High Court, was met with a case where the then Cabinet Secretary of Interior had refused, one, to appear in court and explain the whereabouts of Dr. Miguna. And secondly, it failed to produce Miguna in court. Lord, at paragraph 11 of the decision made by your brother judge, he underscored a fundamental concept. He said, in this case, it is clear that the respondents are the ones in charge of security in this country. They are in effect in charge of execution of warrants of arrest. They have clearly shown that they have no respect for the rule of law and will not comply with the orders of this court. Lord, in reliance upon that limitation, Justice Odinga proceeded to declare the contemnor there as having violated Article 10 of the Constitution. Rightfully so, because we asked for that declaration in order that Fred Matiang'i, the then Director of Criminal Investigation, George Kinoti, and all the respondents should not hold public office. We want Gilbert Masengeli not to hold public office, because this is not his personal property. Lord, the second authority I want to refer you Lordship to is miscellaneous criminal application number 57 of 2018. It's reported as 2018 UK law. But this is a serious enterprise. My classmate Charles is a studious practitioner of law. He asked this. And we argued this case with him. They have been started.
Let me finish, because now we cannot stop the video. And then if you need them to look at the authorities that will be.
That's okay. Thank you so much. Well, the second decision that I'm referring to, that is the case miscellaneous criminal application number 57 of 2018. It's reported as 2018 EKLR. The responsibility, similar to the one bestowed upon you, fell on the shoulder of your brother, Justice Luka Kimaru, a judge in the High Court as he then was. And my Lord, significant to this enterprise is what the judge said about the right to be heard. And this is what he said. If the second and third respondents chose not to appear before court and give their extenuating circumstances, the court will have fulfilled its legal obligation of giving the second and third respondents a chance and a hearing before the final verdict. Not simply put, for the ease